Hello everyone and welcome. My name is Dan Sampaio and I'm delighted to open today's Mondac webinar in association with Kaitan & Co, which will focus on how to resolve contract disputes in India. Before I hand over to our wonderful panel, a quick housekeeping item. We will be hosting a Q&A at the end of today's webinar. Please submit your questions at any time using the toolbar on the right-hand side of your page. It's now my pleasure to hand you over to Kingshuk to begin. Thank you.
Thank you, Dan. Ladies and gentlemen, thank you so much for joining us today. We have an audience. Audience members are from across the globe today. I know it's early for some of you, and I know it's late for some of you. Thank you again for adjusting your schedule for this webinar. My name is Kingshuk Banerjee. I'm a partner at Kaitan & Company. I'm part of the disputes practice group. On behalf of the firm, I extend to each one of you a very, very warm welcome to this webinar. As some of you may know, cross-border transactions in or involving India are today at an all-time high as India emerges. Transactions are often complex, involving multiple parties, documents, contracts, and disputes, if they arise out of these transactions, if not handled well, can take up a great deal of time and money. And therefore, it's sensible to put some thought into how best to approach the resolution of disputes out of these transactions. In the course of the next hour or so, we hope to share with you some very helpful insights on key considerations in resolving business contract disputes in India. We will talk about the dispute resolution framework in India, what works, what may not work. Our experts will share their own experiences and perspectives, which I'm certain will be invaluable. What you see on your screen is the agenda for the day. In essence, it will be an expert panel discussion followed by an audience Q&A and then some key takeaways. We have already received several audience questions, which we will try and cover in the course of our discussions. If you do have more questions, as Dan mentioned, please submit them using the facility provided in the webinar portal. If we cannot cover the questions in the course of our discussions due to paucity of time, we'll try and respond to you offline by email. Please also note that after the webinar, you will receive a summary note of the key issues discussed at the webinar and a link to the recording of this webinar as well. Turning now to our expert panel today, we are very, very fortunate to have with us a set of professionals who have excellent credentials and a lot of experience in dealing with and resolving business contract disputes in India. Joining us today are Jane Kuriakos, who heads the disputes and litigation practice for DXC Technology in Asia, a seasoned disputes practitioner. Matthew Gearing, one of the finest QCs and a member of Fountain Court Chambers in London. And of course, my fellow partners from Kaitan & Company, Raj Panchmadia, who sits out of our Mumbai office, and Kartike Mahajan, who sits out of our Singapore office. Without wasting any more time, let's kickstart the discussion. And Raj, I'm going to request you to answer my first question, really to set the context for our discussion today. And I want to begin by asking you about our judicial system, which, as we all know, is rather complex, can sometimes be very difficult to understand. Can you spend a few minutes broadly and briefly explaining the structure of the Indian judicial system? And could you also briefly touch upon the major challenges with respect to litigation in India?
Sure. Thank you, Kingshuk. And as you rightly said, the Indian litigation system can be a bit complex. The entire judicial system has multiple levels of courts that we need to deal with. So just to give a brief background, so we have Supreme Court right at the top, followed by high courts. We have around 28 high courts in different states, and they're followed by subordinate courts in each state. So there are primarily three tiers of mechanism by which you can resolve your disputes. Initially, you start with the subordinate courts, go to the high court, and then all the way to the Supreme Court. While this is one set of mechanism in which you can get your matters resolved, the other set is that there are also specialized tribunals which have come into play now. Tribunals like National Company Law Tribunal, debt recovery tribunal, securities and appellate tribunal. We have real estate tribunal, that's called RERA. We have electricity tribunal. So we have multiple tribunals as well, and this were brought in specifically to cater to a specialized section of laws. So you would see that you would have securities appellate tribunal looking after securities laws, where a debt recovery tribunal will look after the banking laws. The National Company Law Tribunal will look after the insolvency laws. So there are different kinds of specialized tribunals that have been formed. Even at the High Court and the subordinate level, we now have got introduced something called commercial courts. So each of these courts also have commercial divisions attached to it, which looks after the commercial disputes and commercial value of disputes, depending upon the value of the disputes. Because in India, the first threshold is you have to have a particular amount of disputes to be able to go to high courts. Then you go to the Supreme Court in appeal. So depending upon what is the value of the dispute, it may first go to the district court, that is subordinate courts. In some cases, the subordinate courts have unlimited pecuniary jurisdiction. So you have to also keep that in mind when you are filing proceedings in different jurisdictions. So in India, because of so many different states, you also have to keep in mind that what are the different pecuniary jurisdictions available and where you can go, at what stage you can go. It's very, very important to know. So it starts from the district court, subordinate courts, and goes to the high court, and thereafter appeals to Supreme Court by way of question of law. While these are broadly the different fora that are available to you to go over disputes, but we must also keep in mind that there are some challenges that are there, and we must be aware of those challenges. But these are not stumbling blocks. This can be overcome. We need to be effectively maneuvering the matters in a manner that we don't get stuck in a manner that our matters are not heard. The biggest issue that India faces today is a number of matters that come to court on a day-to-day basis. The number of filings, the number of dockets that are opened on a daily basis. So sheer volume is humongous. If you're looking at volume, it's around 5 crore cases in the subordinate courts which are pending today. So just imagine the number of matters that are there. Around 50-60 lakh matters across high courts and around 75,000 matters around the Supreme Court. Now, these are just numbers that have come up from the national data grid. So these are the huge numbers that you can see. So do we have enough courts, enough judges to deal with this kind of infrastructure? While we may not have full occupancy in all high courts, but I think the government is doing what it can to appoint new judges, to increase the infrastructure, judicial infrastructure. So we can't just blame the government to say that there is not enough infrastructure or there are not enough number of judges. I think the sheer volume of cases is very difficult to deal with. So these are some challenges that we definitely face. Sometimes what you will also see that some of the courts, say instances of Bombay or a Delhi courts, are more savvy with commercial matters, whereas there may be some other jurisdictions where they may not be as savvy on the commercial disputes, but may have some other issues which they can deal very effectively. So we also need to keep in mind that when it comes to complex commercial disputes, which court and which jurisdiction you are choosing to go to. It's extremely important to identify the correct jurisdiction to go to, so that you have specialized judges looking at your matters. The high courts are now creating a situation where they create specialized judges to deal with specialized kind of matters. For instance, for arbitration, some of the courts have actually created a roster which actually hears arbitration matters on a regular basis. So they kind of specialize in arbitration disputes. So this is something that you have to keep in mind. Otherwise, what happens is commercial disputes sometimes get delayed in courts. There is a pendency, and pendency can sometimes lead to long time for the matters to get heard and disposed of. In India, delay is expected in litigation, but we have to be effective, and we need to ensure that we go to the right court to get your matter heard quickly. That's, I think, some of the challenges that I see regularly we face.
Oh, thanks, Raj and Jane. Next one is for you. Obviously, this is all very overwhelming, and the instant idea that comes to mind is that, look, let's try and avoid litigation. And therefore, I want to ask you, and especially given your in-house experience and given that you face these situations very, very often, what would you say are some of the steps that you can take early on in the life cycle of a dispute to avoid litigation?
Sure. So I think the aim of every in-house counsel is to avoid litigation, and whichever jurisdiction, whether it's India or anywhere else. So I think first and foremost, it's really important to have a very robust internal checkpoint with business to identify a dispute early, right? Many times we find that even internal legal gets involved at a time when you have received a breach notice or a legal claim. And that is already a late stage in getting involved in a dispute from an internal in-house perspective. So what we have done, for instance, in DXC business is that we have put an experienced contract services team that reviews our large enterprise accounts, which are entering the red zone in terms of either receivables or our delivery schedule on a monthly basis. And we have digital tools through which, that is a bit more automated. So it's obviously not very manual, and, it kind of helps generate reports faster. And then we realized that there is a lot of discretion and uncertainty on the part of business as to when to get legal involved, right? Even internal legal for that matter. So what we have done is that we have, to remove that discretion, we have financial and delivery thresholds, which if they are hit in terms of, an account, legal reviews are pre-agreed, and the dispute team starts reviewing them on a quarterly basis. And what that has done is we have seen that remarkably reduces the way the dispute kind of pans out or gets into a very mature stage or very complex stage, right? A significant percentage of that falls very quickly. Secondly, this may sound obvious, and there's a lot of in-house people who are attending this, and we understand that a close partnership with business is obviously the underlying aim of an in-house legal counsel all the time. But especially it is important in early dispute management. So a legal should not own the dispute. It should be a business and a legal ownership of the dispute and its outcome. It is not one or the other, especially in its early stage, right? So what we do is we establish a multi-party stakeholder approach to negotiations and dispute at an early stage. And that definitely would involve your finance lead or your business, sales, delivery, depending on your industry, whoever that is. So the business has to be involved in, say, without prejudice discussions early on, establish the relationship separate from your normal day-to-day conversations that you're having with the customer. And that is very useful for us because we need to understand what are their positions. They can they can talk openly and without prejudice discussions. The relationship is built. And we have found that that's a good investment at an early stage, because even if we end up in arbitration or litigation, sometimes we end up settling the matter because that relationship is matured over a period of time, right? So, and we feel it is important that sometimes in this early stage, legal does not have to get involved in these discussions, because then it does get a bit, more aggressive, and that people are taking positions they don't want to back out from. So what we do is we really coach the business in terms of talking points for these, discussions early on, what to say, what not to say, for instance. We map out several commercial outcomes that, is possible at that stage. And, they have ownership of that. So they work with us to kind of achieve that. Of course, we have to be conscious that it can eventually evolve into a legal dispute. So we are trading that fine balance. And I think that is where the timing of getting an external counsel involved is important. And, many times the traditional view is that you get external counsel involved when you know for a fact that you're getting into some kind of ADR or, a legal claim has been filed against you and things like that. But really, I think it depends from business to business when external counsel should be involved. And I think some of the questions is obviously, do you have in-house expertise in disputes for that particular jurisdiction? And if you don't, then definitely you need to get external counsel involved at a much earlier stage. Even if you have that, are you going to take some important steps? Like, is it, a termination letter for in terms of the technology business. That's a big step, right? As a service provider, have you received a really, complex breach notice, for instance? Is there a reputational risk? Is it a media sensitive matter? All of those definitely are questions you should ask, and those are where external counsel, does need to be involved. What we have started doing in DXC on complex disputes is that over the last 2 or 3 years, is that we have got an external counsel involved to give us a legal merit analysis. So once a lot of the work is done in-house in terms of collecting the factual evidence, reviewing, from an internal perspective and discussing with the business, we get external counsel involved to provide us a merit analysis, to tell us, what from a preliminary perspective, and we understand that there are a lot of variables eventually in the litigation. How do you assess the matter, and how do you see it going in his favor, right? And I know that's a tricky position because a lot of external counsel do not want to commit to it, but we have found that even outside counsels have become much more savvy. They understand the matter. They are able to give us a perspective that's very important, because when we go to the business with that, we are able to take quick decisions as to whether we are actually going to litigate. We are going to, how aggressive are we going to go into this litigation? What are the settlement positions we are now comfortable taking or not comfortable taking? So I think that is very important, and definitely in this, I think having a really good panel of counsel that you use regularly is key, because they understand your business. So they are able to, over a period of years, they are able to, kind of get in and advise you very quickly, as opposed to kind of, going to a new counsel every time. So I think that is something very key, and that we really like to focus on.
Well, thank you, Jane. All very, very important points. Matt, I'm wondering if you have anything that you want to add to that before I move on to Karthikeyan.
Yes,
I have a question for him.
Thank you, and thank you very much for the invitation to this very interesting webinar. Yes, just 2 quick points following up from what you said, Jane, and partly based on my experience until relatively recently as a partner in a big international law firm. I think, Jane, all clients say, I've never really met a client who doesn't say, we want to litigate. Clients always say, we don't want to litigate, or sometimes they say, we don't litigate. And of course you say, well, of course, that is the right thing. That's the right sentiment. And if that means that you're looking for disputes and you're trying to avoid the disputes through negotiations or mediations or just reasonable conduct, of course, that's a good thing. But all of these clients who've said that to me, of course, they've subsequently become clients when they've had to litigate, either because they've felt so aggrieved by something that they go on the front foot, or they're on the back foot and defending some claim. So I think that twin track approach that you discussed is right. I think the other really interesting thing you said, well, many interesting things that resonated with me, is how clients organize themselves. And in my view, what tends to happen in most clients is that within a little while, there tends to become an owner of the dispute, often 1 or 2 people, a group. Sometimes it's legal, sometimes it's business, sometimes it's very senior management. I don't know if this accords with your own experience. And that owner, it could be formal or informal ownership, that then really that ownership within a larger organization then drives what happens with the dispute, because of course there could be different motivations. There can be financial motivations, firstly. There can be reputational or precedent-setting motivations over business in a particular jurisdiction, or a form of agreement or something like that. Or sometimes, thirdly, and equally powerfully, emotional investments, where people feel that they were let down. So those 3 levels of considerations, I think they play out differently depending on who has the ownership within the client. And I think as an advisor at an early stage, it's important to work out where the ownership is. Thank you.
Thank you, Matt. Karthikeyan, Jane obviously mentioned negotiation, and we know that's a recognized form of alternate dispute resolution mechanism. But I was wondering if you have any thoughts on mediation and conciliation as modes of dispute resolution. Again, we stay on with the theme of trying to avoid litigation, and are there any advantages? Do these processes work in India? Your thoughts?
Thanks, Kinshuk. Good morning, afternoon, evening, everyone, depending on wherever you are based on this planet. Kinshuk, I think I can safely start by saying that mediation, negotiation, or conciliation are becoming an important first step in any dispute resolution clause in any commercial contract that you will see. I think we are talking about resolution of business disputes, and in the last 7 to 8 years of my practice, I've hardly come across a contract which doesn't say that mediation or negotiation is not a first step before an arbitration or litigation. So that basically shows or underscores the importance of having this as a first step. But in the Indian context, I would like to make 4 points, 2 particular advantages of mediation or conciliation and 2 disadvantages. I'll start with the advantages. I think the first advantage is the more obvious one and something which Jane also alluded to. Mediation can help preserve relationships. It can lead to an outcome which can be a win-win for both the parties. And we may underestimate the power of having 2 important stakeholders from 2 different parties come in front of each other and try and thrash out their differences. But it actually works in a number of situations. It may not work, obviously, in all situations, but it does end up working in a lot of situations. And that's what mediation, negotiation, conciliation try to achieve. And that can lead to a situation in which the business relationships can continue, and you can again go back to where you left before the dispute arose. The second obvious advantage is that if you are able to successfully resolve the dispute, obviously you're saving tons of dollars of legal fees. And I think that's what happens in a mediation or a negotiation scenario. You are not paying the fees of court or an arbitral institution. You're not paying the fees of lawyers who are going to draft lots of pleadings for you if it ends up ending into a formal dispute resolution process like an arbitration or a litigation. Now let's come to the disadvantages. The first biggest disadvantage in the Indian context, and this doesn't necessarily apply, say, in a Singapore context, is that mediation or conciliation settlements are not enforceable per se. What that means is that in order to enforce a settlement agreement, if something goes wrong under it, you still have to go before a court or an arbitral tribunal. Now, under the Singapore Convention on Mediation, you can effectively have a settlement agreement which can be enforceable all over the world, very much like the New York Convention on Arbitration, in which you take an award and you can just enforce it in any of the signatories to the New York Convention. But this convention is still in its nurturing stages, and it will take more time before it gets widely adopted. And having said that, India is actually about to pass a mediation bill, which is pending before the upper house of the parliament, in which it is trying to enforce mediation settlements on the lines of the Singapore Convention. And once that bill gets passed, obviously one drawback which is associated with mediation today will no longer be there. And maybe the discussion that I'm trying to have will become a bit moot. And the disadvantage can be obviously gone to the advantage part. I'll now move on to the second disadvantage, which is that in certain situations, the parties actually don't want to resolve a dispute amicably. They want a definitive solution. They want a definitive answer, a definitive ruling. For example, a construction claim. You don't want to resolve all sorts of questions by mutual mediation, because what you need is a definitive answer as to what constituted a delay event. And that will have a fall-on effect on a number of other construction claims which will come out of the same project. So you would want a definitive answer. Or let's say a shareholder dispute. Sometimes the real value in a shareholder dispute is resolved by having a public campaign. A public campaign can put pressure on a shareholder which is more susceptible to public pressure, as a result of which it can lead to a favorable outcome. So it really depends from dispute to dispute, but obviously you are seeing mediation, negotiation, conciliation as a first step to prevent any such dispute from foraying into the public domain.
Oh, very, very interesting, Karthikeya. But Matt, would you agree that arbitration today is by far the most favored dispute resolution mechanism? I think that's stating the obvious, but just for the benefit of everybody, could you just talk about some of the advantages of arbitration over litigation, especially in the Indian context? Matt, I think you need to unmute yourself.
You've caught me at a bad time, because the case that I have just come out of half an hour ago is an Indian case, and it's been slow and expensive, so I'm not sure I see there are many advantages, but that's only speaking from my last few days. I think, I mean, obviously, you know, I've been practicing since the mid-90s and actually all over the world, but mainly in London and in Asia and very often in India, as you know. And I think arbitration has obviously grown exponentially since then. When I started near here in London as a newly qualified lawyer working with Judith Gill and Alan Nobre, you know, our arbitration group was a really small part of a much broader dispute resolution group. It seems, I think, a sort of a slightly eccentric backwater. And of course, it's grown and grown and grown, and arbitration has really permeated, with the one or two exceptions, almost all forms of contracting, really. There are some exceptions, of course, and some holdout areas. I think largely driven by the cross-border nature of business, really, and the enforceability concerns that arise from having an award that is enforceable under the New York Convention. I think that's really where a lot of the impetus for arbitration comes from. I mean, I think we will have all been to arbitration conferences, hundreds of them, where people bemoan, participants in the process like us, bemoan the fact that arbitration is actually sometimes slow and expensive. It's not supposed to be like that. And one of the great things I do think about arbitration is, in a sense, it's easier for us to, as owners of the system, if you like, to make changes to it if we feel that there are problems. You know, a very good example of that would be an innovation that many of us took part in sort of 10 years or so ago, which is taking part in institutions bringing in the tool of emergency arbitrator, which was some further way of accessing urgent interim relief. That's because it was something that participants had identified as a repeated problem. But generally speaking, of course, arbitration tends to be quicker and cheaper in many cases. I think on the Indian side, of course, there is quite a sharp distinction between domestic arbitration and international arbitration. I've appeared and sat a few times in domestic Indian cases, including in 2 or 3 cases at the moment. And I think you sometimes find yourself being pulled from the old world of very, very slow processes to the fact that, of course, there are strict timelines, or timelines, 12-month timelines from completion of pleadings for rendering an award under the Arbitration Act for domestic cases. And that, I think, is, although it was, it was a controversial amendment when it came in, I think because it was seen as being inflexible, that's actually pushed domestic arbitration in the right direction. And of course, you know, so much of it is actually driven by arbitrators. And in the Indian context, you get, I think, a much broader range of players now on the arbitration scene. So you get younger Indian lawyers, you get Indian lawyers who have practiced in all sorts of different contexts and bring with them essentially a bit more of an international dose, if you like. So international practices merge with Indian practices. In the context of, you know, the most, to me, the dispute that I would see most commonly now in an Indian context would be a Singapore, sometimes London, but often a Singapore-seated arbitration. Kartiki will know all about this. A Singapore-seated arbitration governed by Indian law that's a sort of with a foreign investor or a foreign party and an Indian party, and that would be the classic compromise, if you like. The underlying contract would almost certainly be governed by the substantive laws of India. The seat will be Singapore, and that will be seen as the deal, if you like. And that has, I think that's kind of become the market standard, really. And those cases, although the time limits the time limits under the Indian Act won't apply to those cases, because those would be Singapore-seated cases governed by the Singapore International Arbitration Act. There is really a market standard around the duration of arbitrations. I mean, institutions manage arbitrators, as you all know, so you don't sit on your hands, you're not allowed to do nothing for a long time, quite rightly. Also, though, I think as an arbitrator or as counsel, whenever a case starts, you have a sort of an expectation of a 12 to 18 month time frame. That's how institutions run cases. When I take on a case as counsel or arbitrator, I'm thinking one way or another, the market expectation is this is going to a final conclusion in 15, 18, 12 months, depending on the complexity and so on. I could talk a very long time about this issue, but maybe I'll come back to it more if there is time later, or if you have any questions.
No, Matthew, just staying with you, and since you raised this whole potential different legal systems being involved in an arbitration, you gave the example of a Singapore seated arbitration with governing law as let's say Indian law. How do you navigate that? Because I do feel that that's a challenge that a lot of clients and practitioners face. Are there any tips that you have for us on how best to navigate something like this? How do you plan for this?
I think first and foremost, it's a good idea to make it clear what the governing. We talked about two laws at the moment. We talked about the law of the seat, or the curial law, and the governing law of the agreement, the substantive agreement, which sometimes is called the matrix agreement, or the law of the matrix agreement. There are more laws at play, and the third law, which is sometimes very important, is the governing law of the agreement to arbitrate. There's been a lot of case law about what is the governing law of the agreement to arbitrate in circumstances where it's not specifically fit. Does it follow the seat? So in the example that we have been discussing, King Shuk, would it be Singapore or would it be India, or does it follow the governing law? It's a really good idea to provide for what that is, because that leads to a lot of disputes. And in the Indian context, that leads to a lot of threshold arguments. So a lot of threshold arguments around arbitrability and around essentially the interplay between Indian law and Singapore law. I can talk more about that if you wish, but the most important tip, I think, is to be clear about the governing law of the agreement to arbitrate. And to my mind, it aligns things much more efficiently if the governing law falls into line with the seat of the governing law of the agreement to arbitrate. So in the context of what we might say is our template dispute, you have Singapore law of the seat, which means that the International Arbitration Act applies. You have the agreement to arbitrate is governed by Singapore law, and then you have the matrix agreement, the operational agreement, whatever it may be, governed by Indian law. That would be a sensible way to go, I think, is a sensible way to go.
Understood. That makes sense. Jane, just coming to you now, you've obviously dealt with several arbitrations involving India. What are some of your concerns, key concerns, when dealing with an arbitration involving India?
So, overall, I mean, I would broadly say, coming from what Matt has said, the unpredictability with cost and time is always a concern for in-house teams. We need to sell the arbitration internally to the business guys. We have legal budgets. We track our litigations very closely from a quarter-to-quarter basis. We are a technology firm, so what we do also is that over last several years, we have tracked our litigation and arbitration to see which have resulted and how long it has taken in different sub-jurisdictions, right? So in Asia, for instance, we've done it for India, ASEAN, China, etc. So what we have figured is that especially when there is, in addition to arbitration, there are other ADR mechanisms. We try to predict how things might pan out as much as possible with the help of external counsel, which says, mapping out different outcomes, the cost and time it may take to achieve those. We understand that there's a lot of variabilities, but to the extent possible, given the experience of the counsel that we have chosen, we try to map out what are the different scenarios over a period of 1 year to like 2 years, etc. Right? And that provides always, that when you visualize the different parts, it's obviously to a desired outcome that really clearly helps us make a decision as to how we want to go forward. And this issue with unpredictability on the cost and the time front, it plays on several other issues. Many of our contracts have ad hoc arbitration clauses because by the time, for instance, they're coming in for dispute now, they may have been executed a couple of years back. And while institutional arbitration was, something that was, has been there for around, a couple of years back, I would say ad hoc arbitration clauses were really more popular. And so what, one of our concerns is, the constitution of the tribunal. We've had some cases where constitution of the tribunal has been disputed. So, it's very important to work with your external counsel firm to understand what is the most efficient and the smartest way to approach that with the opposite side, so that, those are not disputed and you can kind of, smoothen it out and start the arbitration as fast as possible, right? Unless, of course, you want to delay the arbitration and that works in your commercial interest, which does happen, of course, with some parties. And leading from that is whether arbitrating in certain cities is better than others because of the high court jurisdiction that may be covered. So where you may need to approach for the constitution of a tribunal or for interim release, we have found differences between Delhi and Bombay. We want to understand if in other cities like Bangalore and Chennai, where we have, where we have more business, how that kind of might pan out. So that's always a concern. And then there is, of course, a seat of arbitration that Matt was saying. There has been an increased push to get Singapore as a seat of arbitration for some of our Indian contracts. But most of our Indian contracts, the governing law has to be Indian law. So from that perspective, there is a concern if the governing law and the procedural law are different. To what extent does that make the arbitration more complex and therefore more costly or more time consuming, for instance? Is a foreign seat. We understand even now when I visit India for the matters that we have, we still get questions from the business that is having a foreign seat of arbitration completely undisputable and settled law. And we know that there's been some recent case laws on that. But really the perspective of business is that, foreign seats are going to be problematic, right? So those are overall, I would say, the main concerns around arbitration. And things have improved definitely in the last couple of years. I think there's much more settled case law in that front. But yeah, this does play, this is an issue for the business.
If you don't mind, can I just step in?
Yes, I was going to ask you before I move to Raj, especially around the foreign seat, having a foreign seat of arbitration. Karthikeya, if you have some thoughts around that.
Yeah, I think, Jane, I'm just going to echo what Matt said, that the perfect cocktail these days is having Singapore's seat and an Indian law as the governing law of the contract. And obviously try and specify the law governing the arbitration agreement. I think there are absolutely no concerns today in terms of having a foreign seat of arbitration, even for two Indian parties, thanks to the recent Indian Supreme Court judgment on this point in GE Power. At the same time, when you have a foreign seat, while you may think that there are certain additional costs which may be involved in terms of engaging a Singapore counsel, in terms of arbitrating outside India, but if you look at the overall process of it, during the entire lifeline of the arbitration, you will find that having done arbitration outside India, it has turned out to be much more cost efficient. The reason why I say that is because if the seat is Singapore, you are going before Singapore courts for any supervisory jurisdiction related stuff like appointment of tribunal, if you have not opted for an institutional arbitration, or asking for interim relief or any other intervention by the supervisory courts. And just for the benefit of the audience, the reason why I keep on saying supervisory courts in relation to the seat is because it is a concept or a legal fiction of arbitration that when you specify a seat of arbitration, it's only courts at that seat which can supervise the arbitral process and no other court. So for example, if the arbitration is seated in Singapore, no court in any other country will try and supervise the arbitral process or facilitate it, except with certain limited exceptions like Section 9 in India Code, which is seeking interim relief. But just going back to what I said before, if you look at the entire lifeline of an arbitration process, having a foreign seated arbitration would be helpful. It is also helpful because the grounds for refusal of a foreign seated award are slightly narrow in comparison for grounds of setting aside. Setting aside happens at the seat of arbitration. So for example, if the seat is Singapore, then the setting aside will happen in Singapore. If the seat is India, the setting aside will happen in India. And if it's in India, the Arbitration Act provides for a patent illegality ground, which effectively means that the court will review the award to see if the arbitrator's view was perverse. So while it's not in effect a review on merits, the court is actually looking at the entire award and adding to the cost. So overall, a foreign seat is quite helpful.
No, thank you, Karthikeya. That makes a lot of sense. Raj, in terms of picking a seat, and I'm glad Karthikeya spoke about what is the significance of the seat. In substance, you're also selecting the court which supervises the arbitration. In the context of an India seated arbitration, Raj, it's not enough to say that the seat of arbitration is India. You would have to pick a city. Do you have some thoughts around that in terms of which cities to pick? How do you determine the seat? How do you pick a seat in India?
Yes, I think seat is very, very important in the Indian scenario, and because seat is your fulcrum of the arbitration, and because all your interim reliefs will go to that court, your setting aside applications will go to that court. Therefore, it's very important that the court, where you are looking to consider moving for your interim application or eventually challenging an award, is commercially savvy and understands the commercial disputes. So it's important that you choose the correct seat of arbitration in India. Just saying, as you rightly said, seat is India will not work. So it's important that you select a seat. Generally, that we've seen in which are arbitration friendly jurisdictions in India are Bombay, Delhi, to some extent Bangalore, which are arbitration friendly jurisdiction. So it's very important that you keep that in mind. One another thing that you have to keep in mind is also where the assets are located, where the assets are of a counterparty within India. So which jurisdiction are you going into? Are we going into a jurisdiction where the assets are also located, or are we going to a completely different jurisdiction? Because then you will, at the time of enforcement, even if you go before the same court, you still for enforcement have to go to a different court.
Yeah.
So all of that is something very, very important that you have to keep in mind. So it's, and also in considering in Indian scenario, you also need to keep in mind what are the disputes which are arbitrable and which are not arbitrable. You don't want a situation where you've gone to an arbitration for a matter which is just not arbitrable under Indian law. So you also need to keep that in mind. But I think overall, to my mind, when you look at the seat, look at the seat which is eventually going to be your seat for challenge. Therefore, it's very important that you go to a right seat in India.
No, and I think that brings me to something very, very fundamental. Most of what we've just discussed can be resolved at the drafting stage of the contract. And Jane, therefore, I want to ask you, how important is it to keep these things in mind when you're drafting your contract? Because otherwise you're leaving it for too late.
Yeah, sure. So, obviously DR clauses, we are a service provider. Like I can tell you from GX's perspective and Hewlett Packard and everything. For us, DR clauses are really important because, just in terms of these are large contracts. There's a lot of money involved. We have to be conscious about where we can go. And, the obvious thing is that, you have to avoid contradictions and inconsistencies in drafting. So, for example, if you want mediation to happen for arbitration, is that a choice for the parties, or is that, mandatory for the parties to explore? And sometimes we feel that, it's drafted as if it's a choice, and then it gets, really messy at the time of, you want to kind of invoke. So obviously that's 101 drafting, I guess, and we have to be conscious about that. But some of the things that what happens is, as a service provider, when we are negotiating contracts, we have to choose our battles because we are not the customer. So there are a lot of other clauses that do end up taking priority, and because of that, for the DR clause, what we do is that we really focus on the big stuff, right? So the last couple of years, we are pushing for institutional arbitration, for instance. And that is something that we want to be very clear about in private sector contracts, right? We want to avoid too many ADR mechanisms. We have seen in India in the public sector contracts that what is being proposed is there'll be like 2 internal escalations. There'll be a steering committee meeting, and then there'll be internal escalations, 3 rounds of that. Then there's a mediation, then there's an expert determination, and then there is arbitration. So basically, we are spending years in trying to get through the ADR clause. And Again, in public sector contracts, we have very less leverage to negotiate too much because it's really take it or leave it kind of situation. So what we try to do there is we try to see if we can just agree totally arbitration, and maybe a steering committee or an internal escalation, or maybe mediation and do away with expert determination, right? I think having too many ADR options is not good. You really need to look at your contract, your business requirements, who the other party is, and accordingly kind of see, what is the APR mechanism that you really want to have in this, and go with that. Keep it short and effective is what I would say in terms of the clause.
Yeah, I think you've said it appropriately. Keep it short and effective, and that makes a lot of sense. We are unfortunately very close to running out of time, but I do want to touch upon one topic which is, I think, very, very important and trending currently, is bilateral treaty arbitrations. And Karthikeya, Matt, very briefly, do you see bid arbitrations as an effective means to resolve disputes in India? Of course, we've had some very controversial cases. Karthikeya, maybe you can briefly talk about those, and we can then hear from Matt.
So thanks, Kinshuk. I think, Kinshuk, the simple answer is yes, we can use investment treaty arbitrations effectively in a proper dispute scenario. Since 2012, when the White Industries Award came out against India, India has seen a flood of cases filed against it, a number of awards passed against it. In fact, there have been statements which have compared India to Argentina in terms of facing the number of investment treaty cases which Argentina did because of its currency crisis and the regulations that it adopted. And India has been facing it because of the simple reason that it ends up taking ad hoc decisions, whether they be legislatively or at the level of the government. And I think a lot of investors, while they have ended up filing, a lot of them don't end up filing claims for two reasons. First, there is just lack of awareness as to how this thing works. People think that it's just a pure public international law, sort of a scenario. You don't really have a commercial claim. They are not well educated and well versed. The second is that they don't want to ruffle feathers with a government in which they will be looking to do business. You look at India, everyone is still investing in India. No one really comes and says that we are packing our bags and moving away from India because it's that big a market. So with that background, I would just highlight three important cases and then possibly ask Matt to chime in. The three important cases that I'd like to highlight is one, Vodafone. The second is Kane. Both of them I can deal together in the interest of time because they both emanate from the same regulation, which was passed in relation to retrospective taxation. Effectively, the government of India amended the Finance Act saying that all withholding taxes in relation to India-related transactions will now have to pay a withholding tax in India. And Vodafone, because it acquired Hutchinson, the government authorities went after Vodafone and said that you are supposed to pay $1.3 billion worth of tax, sorry, $3.29 billion worth of tax. For Kane, there was a restructuring which happened at the UK parent level. And because Kane had some India operations, the Indian tax authorities went and said that you need to pay $1.3 billion worth of tax. And both these companies ended up filing investment treaty awards challenging this legislation and saying that it violated the fair and equitable treatment and ended up getting favorable awards. Now, what is the fate of it? Kane has ended up effectively settling it very helpfully in its own favor, and Vodafone is on the verge of finally settling it. At least that's what the news report says. The third case that I'll say is, again, a matter of ad hoc regulation, and just for the benefit of the viewers, is Nissan's case. Nissan ended up setting up a factory in 2008 in Chennai for its automobiles. It was promised a lot of incentives by the then government of Tamil Nadu. And effectively, when the time for availing those incentives came, Tamil Nadu government said, nothing doing, you're not being given any incentives, and Nissan ended up filing it. And in the course of the arbitration, they ended up getting a favorable award. So the way I look at it is, if investment treaty arbitration is used effectively, you can get the resolution that you want, and you don't have to rely on domestic courts just for your ultimate remedy. Matt, over to you.
Great. Yeah. Matt, maybe some thoughts from you as well.
Yes, I think, Karthikeya, I completely agree with what you've just said. I think just 4 points really by way of follow-up. First of all, the flood of cases against India. Yes, I think you're right. I think there has been that, and for everyone that is in the public domain, there are a couple that are bubbling under, or one's being contemplated, one's being advised on, and so on. I think the flip side of that is that the Union of India, the government of India, have become much better at defending claims, actually. You know, they are, it's become a bit more of a sort of an institution in terms of getting advisors, and not always the same advisors, and experts, and sometimes international experts. And so, you know, India has a strong tradition of litigation, and I think it's sometimes actually been honed quite well now by the government of India in terms of defending claims. I think that's the first point. I think the second point, you said a lack of awareness of treaty rights. I think that's right, but I think that's a lot less than it used to be. It obviously is person specific and client specific, but some clients, generally the multinationals and the multinationals trading in jurisdictions where there's a high risk premium, are pretty aware of their rights, I think, now. And you know, certainly when I was at Allen & Overy, my former law firm, quite often we were actually asked about structuring advice at the outset of investments, where people had, whether it was the corporate lawyers advising or the clients themselves, were specifically thinking about getting the right structure so they could bring a treaty claim as a claimant of a national of a particular state, you know, with a protected investment as and when something went, if and when something went wrong. The third point, Kartiki, I think is really interesting. It comes up a lot, is your what I call your ruffling of feathers point. Like, well, I think that was the phrase you used, ruffling of feathers. Clients think, if I bring a claim, is that the nuclear button? Is that the Armageddon scenario? Will I trade in this country ever again? And I think, I mean, look at Nissan, for example. You know, Nissan bought its claim, successful award, and then a successful settlement, and of course is still trading and prolifically trading, or substantially trading in India. And there are quite a lot of examples of that. So it's not the case, whereas I think 20 years ago, the perception was that a treaty claim was there for a sort of a massive expropriation, where you had been thrown out of the country, your assets had been completely destroyed in some shape or form. I think now it's more of a nuanced instrument, but you're absolutely right, Kartiki. I do think you have to ask yourself about the ruffling of feathers point more in a treaty claim than in a commercial case. And then I think fourthly, in the Indian context, another point from the well, it applies generally, but you can take it from the Nissan case, is attributing the acts of non-central government to the central government, because of course, as you rightly said, Kartiki, what was actually being impugned in that case were not directly the actions of the central government, but principally the actions of Tamil Nadu, the Tamil Nadu state government, in failing to honour its incentives agreement. And it was an agreement, as you said, between the state of Tamil Nadu and Nissan. Union of India may well have thought, and indeed did think, well, hang on a minute, what's this got to do with us? But the answer is, well, you are responsible under public international law for the actions of all of the emanations of the state, of which regional government is one. And you see that actually in quite a lot of different contexts. So it's not just complaining and bringing claims about the actions of central government. It is quite a powerful tool because it engages against all the organs of the state.
Thank you, Matt. We are running out of time, so what I'm going to do now is just turn to just check if there are any questions from the audience. And I do have one question, and perhaps Raj, you can respond to this. Will an interim award passed by an arbitrator at a foreign seat be enforceable in India? This is a very, very common question which all of us are asked, aren't we?
Yeah, I think this is the question comes to us now very regularly after the Amazon dispute, and where the emergency award was being enforced in India. But there's a difference here. If it's an emergency award or an interim award which is seated outside of India, then to enforce in India, you will have to come by way of Section 9, which you'll have to kind of file a Section 9 interim application in India, use the award, as a persuasive value to show that the foreign tribunal has already granted that award. You please grant us relief in terms of that award. You will not be in a position to come and directly enforce that award into India. In view of the recent judgments of the Supreme Court, if an emergency award is seated in India, is passed while seated in India, you will be able to enforce it under 17(2). But otherwise, if it is seated outside, you will not be able to come directly and enforce it in India.
And that applies to interim orders also, right?
Oh,
I mean, it's
absolutely.
Great. What I'm going to do now is, unfortunately, we are running out of time, and we will try and respond to all the audience questions, the remaining audience questions, by email, offline. But in the interest of time, may I request Karthikeya now to just perhaps summarize the key takeaways from the discussion that we've just had now. Karthikeya, if you'd be kind enough to do that.
Happy to. I think from whatever we have discussed, I would call out 3 headline points. The first is that don't think of dispute resolution clause in your contract as a late night clause. Try and put more time into it, think more as to how you want to resolve disputes. A lot of it would be dependent on the quantum of the contract, the negotiating powers involved, as well as the industry that you operate in. Like Jane was talking about the tech industry, you really have to be very industry specific. It's horses for courses. It's not something that you end up applying across board. That's not how it works. And if you want to really go for a mediation first, or a negotiation simpliciter, or nothing at all, because the contract value doesn't demand for it. So you really have to think through it. The second point is get your lawyers involved early on. Try and make them assess the case. Again, something that Jane alluded to, maybe a legal merits opinion might be helpful before entering into a full-fledged litigation or arbitration. A lot of the cases are won or lost depending on the correspondence which has happened before the formal initiation of the case. And I think it might be very useful that you start getting your lawyers involved as soon as the correspondence starts becoming a bit acrimonious. They should screen it, they should give you advice, the right word should be there so that it cannot be taken or held against you later on. The last would be, I think we all can possibly agree that arbitration is becoming the main goal. Arbitration is becoming more and more the preferred dispute resolution mechanism. Questions remain whether that arbitration has to be India seated, it has to be foreign seated, or whether it has to be an investment treaty arbitration. Again, you have to really think through. Nothing is a permanent solution that can apply across board. India seated has its own advantages, like Matt was alluding to, that there is an arbitration bar which is coming about. People are becoming more savvy in India seated arbitration. There are fixed timelines. You're looking at 12 months under the Act with a possible extension of 6 months. Beyond that, you don't get extension. If you do, you'll get it from court. And hardly those extensions have come through. Whereas when it comes to foreign seat, you're looking at a much more advanced legal system like Singapore, England, who would end up resolving your disputes. Those laws of the seat will apply, and overall it will possibly lead to a reduction of cost than an India-seated arbitration, which may have satellite litigation. So you have to think through what you want, what the parties want, and then come up with the right dispute resolution clause. Don't do it in a hurry.
So indeed, I think the importance of a well-drafted dispute resolution clause cannot be gainsaid. And I couldn't agree with Jane more. Handling the dispute well at an early stage could potentially avoid a protracted litigation and possibly an arbitration also. Before closing, I would like to ask each of you to please respond to a poll that you will just see on your screen. If we can just have the poll screen up to provide your feedback on today's webinar. We take this very seriously as a firm, as part of our continuous improvement program. And you have the poll screen up before you. I would also like to thank each one of our guests for sharing their experiences and expertise with us today. Jane and Matt, without you, this webinar would not have been possible. Thank you so much for your insights and staying up late for us and the audience. We truly appreciate it. To our audience, I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, as I mentioned earlier, we will send you a copy of today's presentation materials. summary notes and a link to the webinar recording for you to go over it again. You will also separately receive a request for your feedback on the webinar. Please take the time to send us your feedback, comments, criticism, and well, even compliments. The form takes less than a minute to complete. Don't hesitate to contact us regarding any matters arising from this webinar. Our contact information was on the slide just before this. Thank you again for your attendance today, and we look forward to hosting more such events in the future. Thank you all. Take care.
Thanks, everyone.
Thanks, everyone.